Welcome to Albalex's series of videos on space and tech sector compliance. If you want to learn about compliance in these industries in bite-sized chunks, hit subscribe and follow us to grow your knowledge and empower your business. Today, we're starting our IP-aware series of short videos discussing intellectual property rights within the space industry. In the first of this series, we need to address the major elephant in the space IP room: territorial scope. For many years, space was concerned with exploration with a focus on knowledge, reaching new literal heights. The intention was that such space exploration and the knowledge gained from it should be for the good of all mankind. In the beginning, all of this exploration was backed by government money. The founding principles governing space activities and the treaties in which those rules are enshrined were based upon such principles of space for all. For example, the United Nations Outer Space Treaty of 1967 has the objective of ensuring that exploration and research of space activities are pursued for the benefit and in the interests of all countries, and are the province of all mankind. We can see an example of that intention in practice with NASA. NASA holds thousands of patents, but has made over 100 of these available to the public domain for furtherance of engineering capabilities across the globe. But in the last 10 years, the private space market, the so-called new space economy, which is expected to grow globally to £400 billion by 2030, has seen a significant rise in private money investment, where commercial advantage is key to winning this new space race. And assets that give commercial advantage include IP assets. But IP rights by their nature are monopoly rights. These rights allow the holder to benefit from their invention, their brand, their know-how, and to commercialize it for their own gain directly or indirectly through licensing, for example. Thus, we have an apparent conflict between traditional IP rights granting a monopoly and the likes of the Outer Space Treaty that sees space as being for all. So a balance needs to be struck. But intention is one thing, jurisdiction is another. For registration and enforcement of IP rights, jurisdiction is key. But much like the virtual metaverse, how is jurisdiction in space addressed? To begin to understand that, we need to understand what space is. There is no consistently legislated definition, but typically for other matters such as licensing of launch, the Kármán line is viewed as the threshold to outer space, which is 100 kilometers above the Earth's mean sea level. Definitions aside, what we are missing overall is a catch-all regulation for IP rights in that territory of outer space. We have the Outer Space Treaty, which specifically states that outer space is not subject to national claims of sovereignty and doesn't address IP. We have the UN Registration Convention of 1975, which provides some clarification on jurisdiction by establishing a formal recordation system for physical objects launched into space. Could this tie into source of origin of IP assets and seek to tie jurisdiction to place of registration? Indeed, if we look to maritime law, that's how that works. The place the vessel is registered typically has jurisdiction. On domestic levels, we've seen the recent developments in the UK in space law covering space licensing, for example, but other countries have gone further, and whilst international cooperation remains a work in progress, those countries have taken steps to adapt their domestic legislation to take at least some account of space when it comes to IPR. Countries such as France, Germany, and the US have made their own attempts to clarify the situation for their rights holders. If we use USA as an example, in 1990, it updated its Patents Act to state that any invention made, used, or sold in outer space on board a spacecraft that is under the jurisdiction or control of the US is considered to be made, used, or sold on US territory, unless there is an international agreement in place that contradicts this. But if we become entwined in a myriad of national regulation, the situation could become more complex. So, what solutions have been presented by bodies, the community, and the industry to address territorial scope of IP rights in space? Some say the Outer Space Treaty, given its dominance in space regulation, could be adapted. Some say the UN Rescue Agreement of 1968, which is focused on the safe return of property, particularly astronauts from space, could be adapted. And there is also the registration convention I mentioned earlier that some say could be adapted. That convention actually bears similarity to the one international cooperation agreement that will at least serve as a starting point for discussion. Perhaps, as some would argue, inspiration can be taken from the International Space Station Agreement of '98. The ISS agreement was subscribed to by those countries participating in the design and operation of the ISS, including the US and Canada and European Space Agency member states. This is one global space treaty which does make explicit reference to IP under Article 21, which confirms the position for activities on board ISS, namely that if the activity occurs within a participating member's module of the ISS, that country's domestic laws apply to the matter. The best-known example of this agreement being almost tested in practice was in 2012 in a copyright matter. Canadian astronaut Chris Hadfield performed David Bowie's Space Oddity on board the ISS, with the video being uploaded to YouTube. As he performed physically within a Canadian pod on the ISS, in theory, Canadian copyright law would apply. In this instance, the Canadian Space Agency and Chris himself dealt with Bowie's agents to ensure that permission was obtained. So, the theory was never really properly tested in the same way it would have been if he had not obtained that permission. And certainly by performing in the Canadian pod, it would have kept things much simpler if any dispute had arisen, versus performing midst spacewalk in the undefined vacuum of space itself. It does make you wonder, if we see the day of space tourism, will the music licensors, like the UK's Performing Rights Society, have a new space tariff for music played on the spaceflight? Will we see permission granted for broadcasting of movies on screen as we do on airplanes? Time will tell. Territorial scope is relevant to all different types of IP rights, not only copyright, like in the example of Chris the singing astronaut. And as we continue our series, we will explore other IP rights and their applications in the space industry. Thanks for joining us. Be sure to hit the subscribe button to catch our next episodes in this IP series and our videos on many other space and tech sector compliance topics. And if you need more information or support for your business, including e-training and events, check out our website, albalex.com. Albalex is the orbital and digital compliance consultancy for your needs. So feel free to reach out and let's chat. Have a great day. Thanks for watching.